Good morning, Your Honor. Craig Mueller, back from McDonald.
Good morning, Your Honor.
335-284.
Karen Mishler on behalf of the seat.
Good morning. Defendant filed a supplement. Did you get the supplement?
I did, Your Honor.
Okay. I've read it all. Do you have anything to add?
Your Honor, I have taken every
By the way,
opportunity.
counsel approach. All right.
Your Honor, if I may address the court, and the court has been very gracious in indulging my argument on behalf of Mr. McDonald. But at this point, I really need to make a couple of things abundantly clear. It is the opinion of this officer of the court that these proceedings have been generated into the modern equivalent of electronic image model. I have screamed and complained and taken every opportunity to get this camera and this political organization evicted from the courtroom. I believe Mr. McDonald has been deprived of a fair trial. With specificity and detail, number one, Detective Stanton either affirmatively lied or was so reckless in his disregard for the truth as to, in and of itself, toward a mistrial. Specifically, Mr. Stanton said, I got an anonymous posting from Facebook, and therefore I started an investigation. Facebook does not allow anonymous postings. In fact, the postings from the website were run by Mr. Tessero and his accomplice, Mr. Schoen. Mr. Schoen is, in fact, an employee of Mr. Willick's now wife law firm. Mr. Willick personally committed perjury. I say it loudly and say it directly. I don't want to have to be there, but the fact of the matter is Mr. Willick committed perjury. He got on the witness stand and said he knew nothing about this Facebook page. He had no control over it. I have 5 witnesses who will testify just a month ago that Mr. Willick testified that he had complete control and could remove anything from Facebook and that Nevada court watcher's website. Defense came in here and put on a defense argument that, in fact, Mr. McDonald is being politically railroaded in this case as a result of his association with Mr. Sanson. Mr. Willick was questioned, cross-examined, and then, when confronted with the evidence, lied. Now, he is, in fact, the mastermind behind this website. I have proof for it. I would ask for an evidentiary hearing regarding Mr. Willick's perjury under oath. Specifically, you also have the right, and statutorily, that when a defendant is being accused of crimes that are political in nature, you have, under statutory law 175381, the right to vacate this conviction. I believe that the totality of the circumstances, the behavior of the witnesses, not necessarily personally the state, but the behavior of the witnesses is sufficient here that this conviction should in fact be vacated. Mr. McDonald, whose only crime here is to try to enact some reform over in family court, has been investigated 3 or 4 different times. I'm going to say this with a straight face, Judge. Please listen. 30 years. I've had that job. I've had this job. I've walked into this courtroom with 5 banker's boxes of criminal files as a prosecutor. I've come in here. I've done probably the most jury trials of any practitioner currently before the bar. I have never seen, I don't know of an old-timer, I don't remember when I was a kid lawyer talking to old-timers, ever seen a case where it starts with the idea, we don't like you, we're going to find something you've done wrong. We're going to try this theory first, and if it doesn't work, we're going to try that theory second. If that doesn't work, we're going to try this theory third. If that doesn't work, we're going to go forward on a prosecution. Now, this case is political, it is third world, and it is an embarrassment to the legal system. I'm asking you to vacate this conviction. It is inappropriate. I've got a non-violent first offender who's got 613 days credit for time served right now. He's been in custody for 2 years fighting these cases. Now, this case should be vacated, the conviction should be dismissed, and Mr. McDonald should be free to go about his business pursuant to 175381. I've got a 16-page or 18-page brief that it lays out in specificity and detail then the misbehavior by the same group in the other department is sufficiently warrant to actually put an addendum in this case, so you know exactly what's happened over there. So I'm gonna move to set aside the conviction. If the court's disinclined to set aside the conviction, then I ask the court for a new trial. I ask that Mr. McDonald be released on his own recognizance pending a new trial. And I can't tell you how disappointed I am in this legal system on these proceedings.
Same.
Thank you, Your Honor. Your Honor, there's an old legal adage that when the law is on your side, you bang on the law. When the law is not on your side, you bang on the facts. When the facts are not on your side, you bang on the table. Defense counsel actually creatively has progressed from banging on the table and has decided when the facts are not on his side to simply make up new facts and insist that they are true despite all evidence to be contrary. And, Your Honor, pursuant to NRS 176.015, a sentence must be imposed without unreasonable delay. And there have been nothing but unreasonable delays throughout this case, all due to the actions of defense counsel. And we're now approximately 11 weeks out from a guilty verdict, and the defendant has yet to be sentenced. He was originally supposed to be sentenced on October 30th. It's been over 2 months. It's been nearly 3 months. He needs to be sentenced. And that's the motivation behind these frivolous motions. And Your Honor, I would ask defense counsel to refrain. And Your Honor, there are three things majorly wrong with defense counsel's motion, both the original motion and what he referred to as an addendum. One, neither the original motion nor the addendum contains a single citation to statute or case law. Defense counsel is requesting the extreme remedy of, well, originally he was requesting a new trial, and now he's changed what he's requesting. But he's requesting that without a single citation to case law. He has not demonstrated or even referenced the appropriate legal standard that Your Honor would have to consider when granting or denying this motion. And just now, for the first time, he references NRS 175.381, which doesn't even match what he's requesting because the motion requests a new trial. NRS 175.381 refers to a motion for acquittal, which has to be made within 7 days of the verdict. Further, defense counsel already filed a motion under that statute several months ago, which was denied by Your Honor. And it was in that motion in which defense counsel raised these allegations regarding Detective Stanley. And those allegations regarding the so-called anonymous Facebook posting were rejected. Defense counsel didn't even raise those in the motion before Your Honor, so that argument should just be summarily rejected. Further, the second issue with these motions is that they contain numerous false statements, and at best they're statements that are highly suspect. And I addressed some of this in my written opposition. I don't want to go through every single thing pointing out what's factually inaccurate and what's highly suspect, because really the third issue, that's the third major problem with this motion, is that even if these absurd allegations were true, they don't form the legal basis for the granting of a new trial. And I cited the case law regarding this, Sanborn, Funches, Henney. In order to grant a new trial based upon newly discovered evidence, that evidence must be material, and it must be more than an attempt to discredit or impeach a former witness, which is exactly what this is. And furthermore, defense counsel now is completely unclear about what sort of relief he's even requesting. The motion doesn't even make clear if this is a motion for a new trial based upon newly discovered evidence. That's the only basis it could possibly be, because requesting it on any other basis would be untimely. And nothing that defense counsel has presented falls under the category of newly discovered evidence. Defense counsel just believes he could do a better job of impeaching Mr. Willick. And overall, there have been a number of factual misrepresentations by defense counsel throughout. And what's particularly concerning to the state is the motivation behind this seems to be personal on the part of defense counsel and does not fall under the category of zealous representation of his client, Mr. McDonald. Defense counsel is clearly very unhappy with the activities of pneumatic court watchers, but that is not this court's concern. The fact that they post things that are unflattering to defense counsel is honestly none of this court's concern. Okay, they have free speech rights, which this court doesn't have the right to interfere with. And the only connection that Nevada court watchers ever had to this case is that that happens to be the Facebook page that Detective Stanton was looking at when he first read an allegation of misconduct by Mr. McDonald, and that led to him initiating an investigation. Defense counsel knows that the evidence introduced at trial did not come from Nevada court watchers. Nevada court watchers had very little to do with this case. Mr. Willick was the only witness that had ever engaged in any activity on Nevada court watchers, and the state finds it highly suspect that Marshall Willick is the mastermind behind Nevada court watchers, but even if he were, it's not at all relevant. And as I pointed out in my opposition, Marshall Willick's testimony was relevant as to one specific issue relating only to the perjury counts. Because as part of the elements of perjury, the state had to prove that Mr. McDonald's testimony not only was false, but it was also material to the issue in question at that family court hearing. And that's what Mr. Willick testified about. His testimony didn't even impact the numerous other felonies for which the defendant was found guilty: burglary, forgery, offering a false filing. And defense counsel is now, he didn't even address it here, but now he's claiming that Mr. Willick is posing as someone else and on Nevada court watchers and making postings under a fake name, which seems, again, highly suspect, but again, it doesn't matter to the verdict in this case. Asking for a verdict to be overturned is an extreme remedy, and defense counsel has presented no legal basis for granting that. And defense counsel is not entitled to the benefit of any doubt due to the number of misstatements he's made throughout this case, particularly on December 9th, 2019, informing this court that the defendant's mental health court application had already been submitted, when we now know, based on correspondence, it was not submitted until December 10th of 2019. And defense counsel has used the mental health court application to continuously delay these proceedings. And for that reason, his motion, the addendum to the motion, should be denied, and the sanctions should be ordered pursuant to Rule 7.60.
Carly doesn't answer one substantive allegation. I've seen her asking for an evidentiary hearing and telling she asserts that I'm not willing to prove what I'm saying. I'm ready for an evidentiary hearing to set aside this vacate or set aside that jury verdict. Additionally, my colleague has a huge post-conviction relief remedy for a new trial with post-jury trial before adjudication of guilt, which is a very different area of law. Now, this is a fresh verdict. It is substantive, has been suspect from day one. My colleague did not, cannot, and will not address the selective enforcement arguments at all. Now,
We dealt with that 4 times.
I know, that's why we didn't bring it up orally. Now, the answer is, Judge, this is not the verdict. I've got witnesses.
Okay, what, anything else?
Clear.
All right, denying the motion, and here's why.
I make a finding that paternity has been established.
It was a potential future to his children.
We're here for the court's order to show cause.
Okay, so that takes care of one motion.
Maybe somebody could tell me what the status is.
Any preliminary issues we need to take care of?
You want to make sure that she's put on house arrest?
As you know, the Supreme Court has first of all, most of the arguments that you bring up don't even deal with this case. They deal with another case in another department that has no bearing on this verdict and this particular trial. Your argument that you don't want the cameras in here has been made, I dare say 6 times. And although, you know, I don't say I disagree that cameras are the best thing at all times. They certainly have the right, and our Supreme Court has said that that the media, and I use that in quotes, is allowed to participate in video trials. What media is and the definition is probably for the Supreme Court, but certainly at this point, I've decided that and discussed it at least, as I said, 4 times during trial. They're allowed to videotape. What happened in the other department is really of no relevance. We have no problems per se regarding that in here. For the record, I don't go on any of these websites. I don't pay attention. There are people that follow them intently. Okay, that's their choice. What, you know, gossip, and I'll say that's what it is. Gossip that goes on these websites is of no relationship to this case or this trial. And, okay, so in addition, the other area was previously addressed in the prior motion for both a new trial and vacating or, not vacating this trial, but a new trial. And I believe you made the motion for, it's not a directed verdict, but in a criminal case, and that was also denied. There's been no evidence presented here regarding this motion, only supposition, speculation, and gossip that there is potentially something out there that would affect the one witness credibility, and of course you raised yet again the detective's motivation for investigating what took place. There has never been anything other than the testimony that happened at the trial, which showed that Mr. McDonald forged the document. And yes, you say, and you made the defense that the doctor would have done this, that, or the other thing. That all came out at the time of trial, and the jury still convicted. The perjury, the testimony in court, again, that's on videotape. His salary, etc., what he earned was verified by the witness on the stand. I find no grounds to set aside, to stay, to reschedule or schedule a hearing, or to vacate the trial. Sentencing, we're going forward with sentencing.
Thank you, Your Honor. For the record, my request for an evidentiary hearing is denied.
Yes.
All right, thank you.
State.
And Your Honor, I made a rather lengthy sentencing argument, I think on October 30th. I don't want to reiterate the entire thing. I'll just reiterate. I am asking for a prison sentence in this case. I believe a sentence of 24 to 60 months is appropriate, based largely on the fact that the defendant has demonstrated that he would not be successful on probation. He has a lot of issues with authority. Twice now he's been taken into custody in court, not just in this courtroom, but in the municipal court, and fought with the marshals who were taking him into custody. He has some issues with the corrections officers in CCDC. The records indicate a lot of arguing about whether they have the right to search him and things like that. He's not going to be compliant with his probation officer. I'm sure he will violate his probation very quickly. I don't think he's going to be a good probationer at all. I feel a prison sentence is appropriate, and with that I'll submit.
Mr. McDonald, before your attorney speaks on your behalf, is there anything you'd like to say?
Yes, Judge, if I can speak. Judge, first of all, I want to apologize to this court. This case should have never came before here. I'm still being charged with double jeopardy in family court. It should have original jurisdiction there where I'm being charged for criminal contempt for that sentence. Now, Judge, I discussed with that secretary, asking her specifically for that sentence. It was approved, it was discussed. It was a clerical error. Her secretary went out of the room and forgot to add it. Then I brought it to her attention while I was on the way out. Hey, you forgot to add that sentence. She said, hey, I can't do it now. I have another client. And then I'll do it a different time. I had a new evidentiary hearing, Judge. I haven't seen my kids in almost 3 years. All these charges I have all stem from family court. I've gone nowhere near my ex. I've done everything I can through this family court just to see my children. It's very emotionally soul-ripping not to be able to see one's own children. And I swear, Judge, I had no criminal record. I used to work for the city. I'm not a criminal. I come out and have tried to reform and bring attention to what's going on in the family courts. I even went to Washington, D.C. and lobbied in Congress for the 20th Amendments of the Constitution, which is there right now, called HJ 121, SB 48, for parental rights. I've been doing whatever I can to be able to see them. I had every weekend visitation, and unfortunately my attorney committed suicide, and I went through a terrible divorce. And now I decided to run for office to change the laws, and I get all these felony charges. Judge, I'm getting charged with burglary, 3 counts for filing a document in family court. I had no intent whatsoever to commit a felony by filing a document. My attorney, yet again, I got a new attorney, and he failed me, didn't file anything. I felt compelled to file a pretrial memo, and I rushed it myself. I filed the document, Judge, and then I panicked. I had to do it. I had to file this document. The attorney then was dismissed. I asked Judge Marquis, hey, please, can I get another attorney? I want some time. This case should have been dismissed just on Rule 3.70 alone. I had an attorney record, and I filed a document. It should have been rejected. And then I get forgery charges, Judge. Now, if you look at the Attorney General opinion, forgery is the intent to alter a document with intent to damage or defraud. I had no intent to damage or defraud. I even filed an affidavit that the secretary wrote, said she would have written it, that it was the spirit of the letter. I filed that motion to dismiss. Then Detective Stanton's over there on Facebook. They're posting different things. And I get charged with this forgery charge. I had no intent to damage or defraud. These are my children. I haven't lost my parental rights, Judge. I've had my kids every weekend for a year until I had that trial. And then I get perjury, Judge, perjury charges for filing a financial form disclosure that I filed all those charges. When I got out of jail, I did 6 months in city jail for trying to call my own children. I had contradictory orders saying that I could have reasonable conversations with my kids that came after the TPO order. And Judge Marski said, you will follow my orders till further orders. Judge, all these charges, I've done my best to follow. I've never been involved in the criminal justice system before. I've just been trying to see my children. I'm a good father. I love my kids. And now to get all these felonies, I've even bailed out for $100,000, Judge. $10,000 I'll never see again. I'm out, I get, right before the election, 30 days, I get thrown in, 30 days before I get thrown in jail, in city jail. And I do 8 months. I had 2 suspended sentences, and they wanted to find something against me to get to invoke those suspended sentences, which I had 6 months for texting my parents-in-law how to get presents to my own children. And I did 6 months on domestic violence where she said that I pushed her to custody exchange. I never touched her, Judge, whatsoever. All these charges, it's complete despotism. I've done everything I can to bring forth to be able to see my kids and then to get charged with all this. I also, I get out of jail in April. Finally, after 8 months, I go and I'm ministering to the inmates. I help form I'm a director of a nonprofit out here working on the homeless situation with the courtyard, with Mayor Goodman and Councilman Kaufman. And then I'm out projecting that. We're about to get some grant money and help with that situation. And then I send presents to my kids on Father's Day, 6/16. It was my son's 8th birthday. There was no order saying I couldn't send presents to my children, Judge. And then my ex files a TPO because of presents. The DA, Ms. Mishler, then files a motion to revoke my electronic monitoring. And I get 3 times, you yourself even said, I don't see any order saying he can't send presents to his kids. Then Kathy Hardcastle, who also filled in my divorce case when Marquis went on maternity leave, goes and says, I remember you, Mr. McDonald, we're gonna throws me in jail for sending the presents, Judge. I go before thank God I got a new judge, Judge Moss in family court. And she goes and says, yeah, there was no order, but here, we're gonna put this TPO just as caution. And then I go and I've spent, the last 6 months in jail now, Judge. I don't understand the legal system, Judge. I don't understand how justice can be served. I've done more time than the majority of people in here. I've talked to thousands of people's cases. I'm the jailhouse lawyer here. And I can tell you what, I've never seen so many cases that have been, I've seen complete despotism in our system. People getting jail or prison sentences. How is that going to reform a man? To get from prison to it doesn't help them. They lose their job, their car, their kids, their house, everything. So, Judge, I ask that you please acquit these charges. To get burglary for filing a document, all these charges should have been brought through. I've done enough time, Judge. I just want to get out and get back into life, focus on the nonprofit that I'm a director of. I know a lot of people out here, a lot of good people, and we're working on change. And I hope, change is slow. I mean, even the spirit of Martin Luther King that just happened on Monday. I mean, he had a dream, and Judge, I have a vision to keep families together. I believe that's the root cause of so many social issues: anxiety, depression, mental illness, criminal history, drug use, sex trafficking, mass shootings, all occurring because of breakdown of our family unit. And I tell you, Judge, that it's especially hit me hard for the divorce. I'm the kind of guy that wouldn't have gone through a divorce, and I was alienated when I was 5 from my father, and it especially hit me because I saw him a handful of times growing up, and I know the feeling of having anxiety and having depression growing up because of that. And I didn't want my children to have to go through the same thing. So, Judge, I ask that, yes, I was emotional. I did some stupid things, but I ask that you please quit these charges and let me move about my life and go back and take the proper steps through family court. I'm a lot more educated and more experienced. I can tell you I didn't have all this gray hair before I came into jail as well. So please, Judge, please acquit these charges. I ask for grace and mercy and ask that this to be dismissed, and so I can move on with my life and eventually be able to see my children and be there again. Thank you.
Mr. Mueller, do you?
I've never seen the district attorney office try to intervene in a divorce case before. Now, having said that, Mr. McDonald was a civic-minded man, he was a dedicated parent, he clearly was devastated by the war. He got 615 days credit for the time served. My colleague will never see this case again, we will never see another case like this again. There's absolutely no need for an additional prison sentence. I'd ask for grant of probation, Judge, will do just fine. And in fact, if we put him in prison, he'll be out almost immediately. The state will actually not be as well served as if he got probation, which he will at least be monitored on.
Thank you.
And Your Honor, I just want to say the defendant has 200 days credit.
I hereby adjudicate you guilty of counts 1, 4, and 9, burglary, 2, 5, and 10, forgery. Count 3 was not guilty. Count 6, perjury, 7 and 11, offering false instruments, and count 8, perjury. I assess you the $25 administrative assessment. DNA was, I believe, DNA was not taken until now, so DNA at 150, DNA administrative assessment of $3. Mr. McDonald, the two most serious things are certainly the forgery of the letter from a healthcare, I believe she was a psychologist, who testified on the stand. And there was, my recollection, additional requirements that she would have put in the letter, which are important. You can't just make up your own letter and say, well, she generally would have done that. And second of all, and equally, if not more importantly, this wasn't a case where you testified, I make $12 an hour and you really made $15 an hour. You testified under oath that you didn't have any income, and you totally are ignoring that. You want me to, once again, throw out the charges. I assume that was your request. When the videotape from the case was clear on its face. And these things matter to your children. And yes, I'm sympathetic that you have not had visitation, etc. But on the other hand, a crucial part of that is ordering child support, and you flaunted that, basically thumbed your nose. And so those matters, and the jury agreed, found you guilty on those. Not on the one, they took every one individually. Count 3 you were acquitted of. They considered all of this. I hereby sentence you to 12 to 34 on counts 1, 4, and 9. Count 2, I sentence you to count 2. I sentence you to 12 to 34. Count 5 and 10, 12 to 34. Those counts 2, 5, and 10, 9, and 4 are running concurrent to count 1. Count 6, 12 to 34, again concurrent. 7 and 11, 12 to 34, concurrent. Count 8, 12 to 34 consecutive to count one. The aggregate will be 24 to 68. And they have credit of 200 days.
That's not correct, Judge. I've got the PSI prepared, it's document 533 is our.
Your Honor, defense counsel is looking at the original PSI. They were informed, and I provided counsel with a copy of the updated PSI, which showed the correct amount. I believe they show approximately 156 days as of October 30th.
They showed 600 days when he wasn't, it was impossible.
Actually, I had him remanded concurrent when he was doing the city jail time. I put it on calendar, remanded him on this case. He's actually, I believe he's entitled to that credit.
The original PSI calculated that they mistakenly thought he'd been in custody the entire time of the case, and obviously that was not the case. Otherwise, I wouldn't have filed a motion to remand him. He was out of custody for a significant portion of this
He
case.
gets credit when he was remanded, but not for, not since this case was originated, he wasn't in custody. You don't agree on the 200?
No, sir.
Then show me where it's,
All right, I'll put it on, I'll get the whole paperwork and count it out. But it is, I've got the PSI, I remember very specifically walking him and getting him remanded. That he sat in custody for about part of a year on this case.
all right, we'll bring him back on Monday for the credit for time served.
All right, thank you, Judge.
January 27th, 9 a.m.
Correct.
So you're not ordering the 200?
No. We'll hold off on the JSC until Monday, everything else is done.
Judge, can I
See you. No, we're done.
Pages 5 and 6.